Hi class, so we are going to, I'm going to do a lecture on obligations and contracts, specifically chapter 3, which is the different kinds of obligations based on the lecture, based on the book of Attorney Andrix D. Domingo, the 2025 edition. This is the obligations and contracts, laws, principles, and jurisprudence. Okay? So under chapter 3, we have to further classify the two kinds of obligations, which is the primary classification and the secondary classification. And under the primary classification, we have the pure obligation, conditional obligation, and we also have the obligations with a period. Then we also have alternative and facultative obligations, joint and solidary obligations, divisible and indivisible obligations, and obligation with a penal clause. That's a total of 6 primary classification of obligation. Under the secondary classification of obligations, we have the legal, conventional, and penal obligations. Number 2 is real and personal obligations, determinate and generic obligations. And we have number 4, positive and negative obligations. Number 5 is unilateral and bilateral obligations. We have civil and natural obligations. And number 7, accessory and principal obligation and individual and collective obligations. Okay, so we are going to discuss all the different kinds of obligations under this chapter. Under the first different kinds of obligation is the pure and conditional obligation. When we speak of pure and pure obligation, it is an obligation which is demandable at once. Ibig sabihin, class, under Article 1179 of the new Civil Code, every obligation whose performance does not depend upon a future or uncertain event or upon a past event unknown to the parties, it is demandable at once. So wala siyang di siya dependent sa kahit anong event or past event or unknown, basta unknown to the parties. Ang performance niya, demandable at once. Yan yung tinatawag nating pure obligation. It is an obligation whose performance does not depend upon a future or uncertain event. Okay, there is nothing to exempt the obliger from compliance therewith. Pag sinabi ng obliger na magde-deliver siya ng kotse, i-deliver niya kagad yung kotse kay Y. Okay? So, sinabi ni X, ay magde-deliver ako ng kotse. Wala nang event na kailangan gawin, wala nang kondisyones. It is a simple and pure obligation and it is demandable at once. So, pag sinabing i-deliver ka agad, i-deliver ka agad kay Y. So, wala nang iba. Okay? So, now, ano naman ang kaibahan ng ating conditional obligation? Of course, a conditional obligation is an obligation whose fulfillment or extinguishment depends upon a future and uncertain event. Okay? When we speak of future and uncertain event, syempre meron na tayo dito mga event na tinitignan before an obligation can be demandable. Okay? Example, ano ba yung mga condition muna? Syempre, pag sinabi mong condition, it is defined as every future event or uncertain event upon which an obligation is made to depend. It is the future and uncertain event upon which the acquisition of resolution of rights is made to depend by those who execute the juridical act. Okay? Ang tanong lang naman dito, very, very self-explanatory naman yung ating condition. Siyempre, future event. Ang tanong is uncertain event. Pag sinabi bang uncertain event, paano kung meron kang kausap at tinanong? Ang condition ay pag namatay na si Jose Rizal. Alam naman natin na patay na si Jose Rizal. So, it depends on kung sino ang kausap mo. kung yung taong kausap mo, hindi naman siya sigurado kung namatay si Jose Rizal, can it be a condition? Then the answer is yes. It will fall under dun sa statement na uncertain event. Okay? Kasi hindi sure. But, if yung kausap mo naman, obvious naman, alam niya, napatay na si Jose Rizal, then it cannot therefore be a condition. Because what really reflects on the on condition is, it is a future event and uncertain yung event na yun. Hindi alam. Okay? Merong uncertainty. Okay? So sabi nga ng Supreme Court, when the obligation assumed by a party to a contract expressly subjected to a condition, the obligation cannot be enforced against him unless the condition is complied with. Okay? So importante yon. Now, I have to mention also that under Article 1179, as I have mentioned earlier, the second paragraph clearly stated that every obligation which contains a resolutory condition shall also be demandable without prejudice to the effects of the happening of the event. Mamaya ikikwento ko yung second paragraph na yan ng Articles 1179 class. But it's important right now that you have a copy of all the articles embraced sa ating obligations and contract. Diba? Na-mention ko naman before na iilan lang yung batas na yan. So, kahit paano, maybe you can download it and print it para hindi naman kayo malito. Because it's important that you know the coverage of the subject matter. So, magsimula lang kayo dun sa obligations, which is Title 1, under Chapter 1, which is nagsisimula sa Article 1156. Okay? So now, as to the effect of obligation, we move now to suspensive condition and resolutory condition. So, move na tayo sa next na kinds under the primary classification of our obligations. Ito yung tinatawag na suspensive condition. Yung suspensive condition is the fulfillment of the condition results in the acquisition of right arising out of the obligation. Mamaya bigyan ko example for you to understand it clearly. Resolutory condition, the fulfillment of the condition results in extinguishment of right arising out of the obligation. Okay? The difference. Dito sa suspensive condition class, if the suspensive condition is fulfilled, the obligation arises or becomes effective. On the other hand, pag ang resolutory condition is na-fulfill, the obligation is extinguished. Okay? Number 2, if the suspensive condition is not fulfilled, no juridical relation is created. Yun ang sa suspensive. Sa resolutory, if the resolutory condition is not fulfilled, the juridical relation is consolidated. Ulitin ko ha, if the resolutory condition is not fulfilled, the juridical relation is consolidated. In suspensive conditions, rights are not yet acquired but there is a hope or expectancy, may chance that they will soon be acquired. Resolutory condition, on the other hand, in resolutory condition, rights are already acquired but subject to the threat of extinction. Okay, bigyan ko kayo ng example for you to understand this. Okay, pag sinabi natin, bibigyan ko na lang kayo ng simple para mas madali nyo maintindihan. Halimbawa, si X, okay, si student X, nanay niya si M, sabi ng mommy niya, o anak, bibigyan kita ng kotse pag ikaw ay nakapasa sa subject mong obligations and contracts. Okay? Anak, bibigyan kita ng kotse pag ikaw ay nakapasa sa subject mong obligations and contracts under Attorney B. Okay? Ganun lang kasimple. Nakapasa ka. So, meron kang suspensive condition. The suspensive condition is pag nakapasa ka ng obligations and contracts kay Attorney B. So, bibigyan ka ng nanay mo. Yun ang kondisyon. Suspensive siya kasi hindi mo makukuha ang iyong kotse kung hindi ka makakapasa. Pero pag nakapasa ka, that's the only time mo makukuha ang iyong kotse. Kuha, class? O now, when we speak of resolutory, class, ang resolutory is nandun na, naibigay na sa iyo yung obligasyon. Mai-extinguish lang kung yung kondisyon ay natapos na. Okay? Ano naman yon? Anak, itong coaching ito ay sa iyo habang ikaw ay nag-aaral ng obligations and contracts under Attorney B. Ulitin ko ha, anak, sa iyong kotse ay sa iyo habang ikaw ay nag-aaral ng obligations and contracts kay Attorney B. Okay? Ganon. Paano kung tapos ka na makapag-aral? Then, the condition is fulfilled, thus, the obligation is extinguished. Pwede nang kunin ulit yung kotse sa iyo dahil na-extinguish na, fulfill na ang iyong obligation. Naintindihan nyo, class? Kasi fulfilled na Ang obligation is yung kotse. Gamitin mo habang ikaw ay nag-aaral. Ano yung condition? Pag nakatapos ka na ng obligations and contracts kay Attorney B, therefore, the condition is fulfilled, thus, the obligation is now extinguished. So, importante rin, class, dun sa suspensive kasi, hindi pa nagagawa yung kondisyon. Kaya, hindi pa naibibigay yung kotse. On the other hand, naibigay na yung kotse. Now, pag na-fulfill yung obligation, nakapasa ka na kay Attorney B ng iyong obligations and contracts, then, pwede nang bawiin yung obligation. Tapos na yung obligation. Okay? So now, that is your suspensive and your resolutory condition. Okay? As the right to the origin of condition. So, pag sinasabi natin, kanino ba talaga yung condition ng nag-originate? So, pwede rin potestative condition kung ang fulfillment ng condition ay depends on the will of one of the parties. Kung either it is the debtor or the creditor. Potestative ang tawag doon. When you speak of casual condition, the fulfillment of the condition depends upon the chance or upon the will of a third person. Ito yung mga tinatawag nating kondisyones na pwedeng pag nanalo ng sweepstakes, pag nanalo ng loto, wala na palang sweepstakes. May sweepstakes pa ba ngayon? So, yun yung mga casual condition. When we speak of potestative, depende yan. Kung either debtor or your creditor. Pag sinabi mo namang mixed, the fulfillment of the condition is dependent partly upon the will of the party of the obligation or chance or will of a third person. Okay? So, mix siya nung dalawa. So, yun yung tinatawag nating kung saan nanggagaling yung kondisyon. Ang example nito is for potestative, o sa'yo na itong relo ko. If ako ay pupunta ng mall today, that is potestative. O pag sinabi mong casual, I will give you my bicycle kung uulan ngayon. Diba? That is based on a chance. At sasabihin mo naman kung ito ay mixed condition is, I will give you my only car if I will go to the shopping mall and kung uulan ngayong araw. Okay? So that is a mixed condition. Okay? So what is the rule in mixed conditional obligation? The existing rule in a mixed conditional obligation is that when the condition is not fulfilled, but the obliger did all in his power to comply with the obligation, the condition should be deemed satisfied. That is the basic rule. Okay? So, ulitin ko lang ha. The existing rule is mixed conditional obligation is that when the condition is not fulfilled, but the obliger did all in his power to comply with the obligation, the condition should be deemed satisfied. Now, as to possibility, possible and impossible. Pag sinabi mong possible, the condition is capable of realization. Pero pag impossible, malabo. Mas malabo pa sa 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 dugo ng pusit o ng tinta ng pusit. Okay? Not capable siya, not only by its nature but against the law, morals, good customs, public order, or public policy. Pag sinabi mong morals, good customs, public order, and public policy, at syempre batas, pag sinabi ng batas na hindi pwede, hindi pwede. Di ba? Kahit halimbawa sabihin, walang batas kunyari na bawal maglakad ng nakahubad, against public policy or public order yun kasi nakakagulo lang kayo. Di ba? So, hindi rin pwede yun. That is considered an impossible condition. As to mode, of course, there's positive and negative. The condition involves the performance of an act. At pag sinabi mo namang negative, non-performance of an act naman. Pag sinabing positive kasi gagawin. Pag sinabing non-negative, non-performance of the act naman. Okay? As to divisibility, sinasabi na natin when we say divisibility, ito yung the condition is susceptible to partial realization, that is divisible. So pwedeng hatiin. Indivisible, the condition is not susceptible of partial realization. Hindi pwedeng hatiin. Do pwedeng mahati, pero hindi pwedeng hatiin. Okay? As to numbers, conjunctive condition, there are several conditions, all of which must be realized. Alternative condition, there are several conditions, one of which must be realized. So, yun yung kaibahan. Maraming kondisyones, pwedeng dapat gawin, yun ay conjunctive. Alternative, maraming kondisyones, pwedeng isa lang ang magagawa. Okay? As to form, express condition, the condition is sinasabi, nakasulat, alam, naintindihan. Implied, the condition is tacit or nakatago. Or, pag sinabi mong implied, ito yung parang napag-usapan. Okay? Hindi siya directly napag-usapan, pero parang napag-usapan. Compared mo sa express, pinag-usapan. Okay? So, implied. Yan ang other word for tacit. Express, nasabi. Okay? Parang nasabi. Yung isa, parang nasabi ganun eh. Medyo kaduda-duda. Okay? Now, period. A time is of definite length. Yan. Pag sinabi mong period, meron definite length yan. Definite, having a distinct or certain limits, determinate in extent of character. Limited, fixed as definite period. Okay? Ano ba yon? Ano ba ibig sabihin nun? When I have the money, as soon as I have money, when can I offer? Okay? When can I afford to pay? Diba? Yan yung mga part na kaduda-duda, pero in a way, pag may pera. Ang problema, paano pag hindi dumating yung pera? But still, it is a period, class. Okay? Now, potestative condition, napag-usapan na natin kanina. A condition whose fulfillment depends upon the sole will of one of the contracting parties. Impossible condition, the condition is not capable of realization according to law, nature, public policy, or good customs and public morals. Actually, kasama dyan. Ano ba yung mga kinds of impossible conditions? Physical impossible condition and legal impossible condition. Okay, yan yung mga different kinds of conditions dun sa part na yan. What is divisible obligation, class? Divisible obligation is those which have as their object which is susceptible of partial performance without the essence of obligation being changed. Okay? Ito yung mga ating mga obligasyon na hindi naman natin sinasabing buo, pero ito yung obligasyon na pwedeng hatiin. Pwedeng partial performance ang pwedeng gawin. Okay? Yun yung kagandahan sa ating divisible obligation. Okay? What else? Under the doctrine of constructive fulfillment of suspensive condition, under Article 1186, the condition shall be deemed fulfilled when the obliger voluntary prevents it. Okay? That is according to your 1186. Under this, ito yung tinatawag nating constructive fulfillment of suspensive condition. Pag yung mismong obligor ang gumawa ng paraan para hindi matuloy yung pag-fulfill ng kondisyon, then it is as if nagawa na yung kondisyon. Okay, tandaan nyo yung klasa, it is as if nagawa na yung kondisyon. Because the intent of the obliger is to prevent the fulfillment of the condition. And, of course, the actual prevention of the fulfillment. Kung talaga namang hindi natuloy, dahil dun sa kalokohan ng obliger, then, it is as if the condition has been fulfilled. Okay? Principle of retroactivity. Principle of retroactivity in suspensive condition. It is limited only to the effects of the obligation. In obligation to give and in obligation to do or not to do. Okay? Retroactive effects as to the fruits and interests to the obligation. Class, ito, importante ito. There is no retroactive effect. The fruits and interests during the pendency of the shall be deemed to have mutually compensated. Ibig sabihin nun, class, retroact, ibig sabihin, ito ba ibabalik kung saan doon nangyari yung kondisyon? Well, basically, class, yung pinaka-effect nun, ito ay deemed to have mutually compensated. Ibig sabihin, hindi siya babalik dahil ang iniisip lang ng batas dito, sila ay parehong nag-compensate, sila ay parehong nabiyayaan. Kaya, yun yung ibig sabihin ng ating retroactivity ng fruits and interest. It is clear under Article 1187. Okay, sabi sa ating Article 1187, the effects of a conditional obligation to give, once the condition has been fulfilled, shall retroact to the day of the constitution of the obligation. Kung yun yung sitwasyon. However, nevertheless, when the obligation imposes reciprocal prestations upon the parties, the fruits and interest during the pendency of the condition shall be deemed to have been mutually compensated. Okay? Okay, maglagay tayo ng magbigay tayo ng simpleng example. Okay? Example. Tingnan natin under the book of under the book of Attorney Domingo. Okay. Sabi dito, class. Okay, I will try to simplify the story. The subject of this case merong lupa. Okay, the original owner was X when the same was subject to expropriation proceedings. Yung expropriation, yung kinukuha ng gobyerno yung lupa. Okay? Para dun sa expansion and improvement of Lahug Airport kasi itong lupang ito ay nasa Cebu City. During the expropriation proceeding, si Y na-acquire niya yung property ni X. The trial court rendered judgment in favor of na dapat daw ito ay makukuha ng gobyerno. At sinasabi na yung property is bayaran si Y dahil si Y yung nakabili ng property ni X. The affected landowners nag-appeal, syempre. Sabi nila, ay, teka lang, meron tayong issue. So, kailangan naming mag-appeal. Okay? Now, anong sabi ng Supreme Court dito? Sinaklaro na lang natin kung ano yung sinabi ng Supreme Court. Is Article 1187 ba of the Civil Code applicable? Yung sinasabi natin compensated or mutually compensated? Okay, sabi, in the light of the premises, the Supreme Court expressly held that the taking of the private property consequent to the government's exercise of the power of eminent domain ng gobyerno, ito yung expropriation, pareho lang yon, is always subject to the condition that the property devoted to a specific public purpose for which it was taken. Okay? Corollarily, if this particular purpose or intent is not initiated or not at all pursued and is peremptorily abandoned, then the former owners, if they so desire, may seek reversion of the property, subject to the return of the amount of just compensation received. In such case, the exercise of power of eminent domain has become improper for lack of the required factual justification. Okay? Following Article 1187, the Mactan or yung ating gobyerno may keep whatever income or fruits they have received obtained from the lot. And si Y naman being hindi niya na kailangang i-account yung for the interest that the amounts they receive as the compensation may have earned in the meantime. So, siyempre, sinasabi na kung hindi matutuloy, di ba? Hindi naman natuloy yung kanilang pag-purchase ng property. So, kung ano man yung mga benepisyo na nakuha ng gobyerno during the holding of the property, edi kanila na yon. In the same manner, kung kumita yung pera na hawak ni Y, dahil binayaran sila ng gobyerno, hindi na nila kailangan ibalik. So, pareho na sila. Ina-assume ng batas that they have been mutually compensated. Yun yung ibig sabihin ng class. Okay? Naintindihan? Okay. Good. Now, ano ba yung mga rights of the creditor before the fulfillment of the condition? The creditor may, before the fulfillment of the condition, appropriate actions for the preservation of his right. Okay? Ano yung mga pwede niya gawin? Gawin niya lahat ng aksyon, kahit magkaso pa siya, basta ma-preserve yung kanyang karapatan. Okay? As to the debtor, before the fulfillment of the condition, the debtor may recover what during the same time he had mistakes in case of suspensive condition. Okay? In the same manner, the debtor naman, pwede siyang mag-recover kung ano man yung mga pagkakamali pag ito ay suspensive condition. Sinabi na dito, very clear, dapat suspensive condition. Okay? This is important class, loss. Kasi maraming akala ng loss na wala lang. Okay? Nawala. So, hindi ibig sabihin nun, nawala lang, class. You have to understand, before we proceed, dito sa Article 1189, sinasabi kasi rito klase 1189 ha, bago ko discuss fully yung lost. Sabi ng 1189, when the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss, or deterioration of the thing during the pendency of the condition. Sabi yun ang first paragraph ng Article 1189. It is important because ano ba ibig sabihin ng loss? Ito ba yung nag-disappear? Yes. Pero bukod sa disappearance, sinasabi rin ng batas class, ang lost, ibig sabihin, nag-perish din, nasira. Okay? Pwede rin, it goes out of commerce. Pag sinabi mong disappear, syempre madali yun, nawala. Okay? Yung relo ay nawala. Yung mangga ay nabulok, ay nasira, ay nag-perish. Yung goes out of commerce, wala nang analog ngayon, digital na lahat. Okay, that is goes out of commerce. So halimbawa, nagtitinda ka ng mangga, hindi mo na pwedeng ibenta ito because it is already considered lost if it perishes, kung ito ay nasira. Nagtitinda ka ng analog, hindi na kailangan, wala na mapagagamitin yan, then it goes out of commerce. It is also considered lost. Disappear, class, it is self-explanatory. Okay? Now, what are the rules according to your Article 1189? If the thing is lost without the fault of the debtor, the obligation shall be extinguished. That's the first rule. If the thing is lost without the fault of the debtor, the obligation shall be extinguished. If the thing is lost through the fault of the debtor, the debtor shall be obliged to pay damages. If the thing is lost, nawala through the fault of the debtor, magbabayad na siya nung obligation plus may damages pa. When the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. Ganun lang din yung class. Kung naluma, bumagsak ang quality, wala ang kasalanan ng debtor, then si creditor ang magsha-shoulder nun. Okay? Number 4, if it deteriorates through the fault of the debtor, the creditor, halimbawa may kasalanan si debtor sa pag-deteriorate nun, then the creditor may choose, pwede niyang sabihin na ayaw niya na ng obligation at saka yung fulfillment, kailangan lang magbayad si debtor. Okay? May damages. Yun tatandaan nyo. Pwedeng i-rescind, itigil na yung kontrata class. Ibig sabihin nun. Okay? If the thing are improved by its nature or by time, the improvement shall inure to the benefit of the creditor. Kung dun sa isa, wala namang kasalanan si debtor, siyempre, ang magsasakripisyo sa creditor. Dito rin, pag gumanda, at through nature, ay swerte rin si creditor, sa kanya mapupunta. If it is improved at the expense of the debtor shall have no right than granted to the usufructory. Okay? Ano ba ibig sabihin ng usufruct? It gives the right to enjoy the property of another with the obligation of preserving its form and substance unless the title constituting it or the law otherwise provides. Okay? Huwag niyong basahin muna yung second sentence, pero more on sabihin nyo, halimbawa, ako, pinahiram ako ng property, kunyari, si X, pinahiram ng property sa akin yung property niya. So, nandun may puno ng mangga. Inalagaan ko, inaayos ko. So, kung ano man yung bunga doon, class, sa akin yung bunga noon. Pero hindi ko dapat sirain yung property kasi usufructory lang ako. Okay? Ako lang ay, ini-enjoy ko lang, bini-benefit ko lang yung property ng iba. Pwede rin sa cellphone yan, class. Basta huwag mo sirain, pinahiram sa'yo. Sabi, mag-alcohol ka, kasama yung sa benepisyo ng paggamit ng telepono. Okay? Now, what else? I will pass the rights of usufructory. Ganun lang naman kasimple yun. Now, effect of fulfillment of resolutory condition in obligation to give. Ano ba yun? The parties upon the fulfillment of said condition shall return to each other what they have received. Yan yung kinikwento ko kanina regarding the resolutory condition. Okay? So, kasi, dito class, ibig sabihin, yung resolutory condition kasi, it is the extinguishment of the obligation. So, nagawa na yung obligasyon, natapos na yung obligasyon, you have to return, nagawa na yung condition. So, the obligation is now deemed performed. Okay? The condition is deemed fulfilled, so kailangan na yung obligation extinguished na. Okay? Yun yung ibig sabihin lang ng part na yon. Now, this is to give. Paano naman yung to do or not to do? In obligations to do and not to do, the court shall determine in each case yan class, the retroactive effect of the condition that has been complied with. So, it is the court who will determine ano ba yung dapat gawin, ano ba yung dapat mangyari. Okay? So, that is your resolutory. So, yung rescission, I have already explained. Itong ibig sabihin nun is unmaking a contract or undoing from the beginning, not merely its termination, but undoing or unmaking the contract. To rescind is to declare a contract void. So, pag sinabing i-rescind yung contract, di void yun. Pag sinabing rescission, i-unmake mo yung contract. Yun yung explanation ko sa inyo kanina. Okay? Reciprocal obligation, sinabi sa reciprocal obligation, reciprocal obligations are those which arise from the same cause wherein each party is a debtor and a creditor of the other, such that the performance of one is conditioned upon the simultaneous fulfillment of the other. From the moment one of the parties fulfills its obligation and delay by the party begins. Okay? Pag na-fulfill ng isa, dun nagkakaroon ng delay. Of course, nag-uusapan din natin, demand is important in delay. Okay? Now, reciprocal obligation, siguro naman, as a very simple example is pag sinabihan ka ng I love you ng inyong boyfriend to reciprocate, yun yung term, reciprocate. Totoo ba yung nararamdaman yan? You say I love you also, if that's true. Kaya nga reciprocate, reciprocal, I love you and I love you back. Diba? O, pangit naman kung I love you, tapos yung isa I love you 3,000. Okay? So what else? What is mutual restitution? Mutual restitution is required in cases involving rescission. This means bringing the parties back to their original status. So, siyempre, pag na-rescind na yung kontrata, ano mangyayari? Ibalik na. Ano ba mangyayari? I-restore. When you say restitution, i-restore kung ano man ang nangyari before. I-restore na lang natin pabalik. Okay? So that is mutual restitution. Extrajudicial rescission explained. Extrajudicial rescission of the contract is not possible without express stipulation to that effect. Okay? Ibig sabihin, kailangan nakasulat yan. Express, di ba? Tinuro ko kanina, as I have mentioned earlier, express. Kailangan sinabi, sinulat na merong outside court rescission. Pag sinabi mong extrajudicial sa labas ng korte. Okay? So, what are the alternative remedies of injured party? Fulfillment of the obligation with damages. This refers to specific performance. Diyan napapasok yung sinabi ko, di ba? I remembered lecturing it to you, specific performance. Sabi ng dictionary, ng Black's Law Dictionary, it is the remedy requiring the exact performance of a contract in the specific form in which it was made or according to the precise terms agreed upon. The actual is accomplishment of a contract by a party bound to fulfill it. Okay, yan yung tinatawag nating specific performance. Okay? Now, we move to what is obligation with a period. Siyempre, ito yung meron ng whose fulfillment a day certain has been fixed. Okay? And shall be demandable only when the day comes. An example, X promises to give his particular cell phone to Y on make it February 14, 2025. So, dapat pagdating ng February 14, bibigay na yung cellphone. Kasi ang sinasabi ng day certain, it is understood to be that which must necessary, although it may not be known when. Moreover, when the debtor himself to pay when his means permit him to do, so the obligation shall be deemed to be with a period. Okay? Yun yung tinatawag nating may period. Ano ang kaibahan ng condition sa term or period? Condition refers to an event. A term or period refers to an interval of time. Condition has for its requisite futurity and uncertainty. The term period has for its requisites futurity and certainty. A condition may or may not happen. The term period will surely come to pass, although it may not be known when. A condition exerts an influence upon the very existence of the obligation itself. A term or period exerts an influence only upon its demandability. A condition has retroactive effects. A term or period does not have retroactive effects unless there is an agreement. Agreement to the contrary. When a condition is left exclusively to the will of the debtor, the very validity of the obligation is affected. When the duration of the term period is left exclusive to the will of the debtor, the obligation is still valid. Class, tandaan nyo itong mga difference na to, ha? This is important that you understand this. A condition must be possible, otherwise the obligation is void. Yan sinasabi yan, dapat posible yung condition. Kahit na hindi magawa, pero dapat posible. At, of course, legal. A term period or a term must be possible, otherwise the obligation is void. May period bang imposible? Pag hindi namatay, lahat naman kasi mamamatay. Di ba? Okay? What else? As to different kinds of period, as to effect, there is suspensive period. Ito yung tinatawag nating XDA. Resolutory is INDM. Obligations for whose fulfillment a day certain has be fixed shall be demandable only upon when the day comes. Ito yung suspensive. Di ba? Yung resolutory is different because yung resolutory, it take effect once. Di ba? Meron na kaagad eh. Meron na kaagad obligasyon na nagawa ng obligasyon. Okay? Pero na-terminate to once the arrival of the day certain. Okay? As to expression, express. Dapat specifically stated. Pag implied, ito yung sinasabi natin na not so sure. Diba? Gaya ng, I will pay you when my means permit me to pay you. Diba? Hindi mo lang kasiguraduhan. Pero magbabayad ako. So that is implied. Now, what else? Definiteness, definite period when there is a fixed date. Indefinite when there is no fixed date. Conventional when the period is agreed upon by the parties. Legal when the period is fixed by law, and judicial fixed by court. So, conventional, parties, legal, fixed by law, judicial, court ang nagsasabi niyan. Okay? Now, ano bang effect ng payment in advance? In obligations to give, the debtor can recover what he has paid or delivered with the fruits and interest. However, he cannot recover if he delivers the thing voluntarily, deliver yan class, voluntary, or with the knowledge of the period or term, or the fact that the obligation has not yet become due and demandable. Okay? Dito, sinasabi lang naman, ano magiging effect pag nagbayad ka in advance? Okay? Pag obligation to give, the debtor, pwede niyang bawiin. Bawiin ko na interest kasi hindi pa pala to due and demandable. Pwede niyang bawiin. Pero pag nagbigay siya voluntarily, well, wala tayong magagawa. Binigay mo na eh. Binayad mo na eh. Okay? Ganun naman kadali ang ating batas class. Understanding ang batas natin. Okay? Period has been established in favor of the debtor. It means that the debtor cannot be compelled to perform obligation prematurely, but he can do so if he desires. Pag na-establish ang ating obligation ay, or ang period ay para to favor the debtor, well, you cannot compel it prematurely. Hindi mo pwedeng sabihin, ay gawin mo na to ngayon. Alam naman natin na para sa debtor yun. But when the period has been established in favor of the creditor, ibig sabihin naman ito, it means that the creditor may demand the fulfillment of the obligation at any time, but the debtor cannot compel him to accept payment before the expiration of the period. Okay? Simple, naman yon. Self-explanatory. When the debtor loses right to make use of the period, when after the obligation has been contracted, he becomes insolvent unless he gives guarantee or security for the debt. Okay? Sabi niya, napag-usapan nyo, meron kayong time kung kailan magbabayad, pero ito yung mga imposible na kasi insolvent ka na. Okay? Papayag lang naman ang kung nabawa. Sige, extend mo pa, okay lang. Basta magbigay ka sa akin ng guarantee or security sa debt. Diyan pumapasok class, yung mortgage. O sige, sanla ako sa ito. Sige, mas extend mo. Okay lang. Pero kung wala ka na talagang pera at wala ka na ibigay na guarantee or security para sa utang mo, bayad ka na kagad. Okay? Now, simple obligation. An obligation when there is only one object. Compound obligation. An obligation, there are two or more objects. So, pag marami, compound. Pag isa lang, simple obligation. Dito napapasok yung ating section 3 in different kinds of obligation based on alternative and, of course, facultative Okay? So, nasa na? Una, conjunctive obligation. There are two or more objects and all of them are due. All of the objects must be performed to extinguish the obligation. Distributive obligation, an obligation where one, two or more of the objects are due. One, if the objects must be performed to extinguish the obligation. Ito yung mga compound obligation. Okay? What are the different kinds of distributive obligation? Alternative obligation, two or more objects are due, but the performance of one is sufficient. Facultative, an obligation where only one object is due, but the debtor may substitute another object. Okay, dito sa alternative, meron kang maraming kang pagpipilian kung ano yung pwede mong gawin. Sa facultative, isa lang, pero pag hindi mo nagawa, pwede kang mag-substitute. Yan ang ibig sabihin ng facultative. Okay? So, of course, may difference pagdating dun sa effect ng alternative and facultative. So, pag sa facultative, alternative, pag nawala due to fortuitous event, all of the objects are lost, the obligation of the debtor is extinguished. Okay? Extinguished. Purado. Tanggal. Only one of the objects remains, the debtor must deliver to the creditor the remaining object. Siyempre, consequently, the obligation ceases to be alternative and it becomes a simple obligation. So, ganun din yun, class. Pag nawala 5 ang pinagpipilian, nawala yung 4, isa na lang. So, it's no longer an alternative, but rather, it becomes a simple obligation. Isa na lang ang iyong pagpipilian, wala ka ng choice. So, yun na lang ang obligasyon mo. Pero pag 2 or more objects remain, the debtor must deliver that which he shall choose among the remainder. Consequently, the obligation still subsists, retaining its alternative character. Kasi may natitira pa naman. Dalawa pa naman yun, class. So, pwede pa rin mamili. Okay? Now, paano ngayon? Kung lost due to debtor's fault, all of the objects are lost, the creditor shall have the right to indemnity for the damages based on the value of the last thing which disappeared or service which becomes impossible. Damages other than the value of the last thing or service may also be awarded. Parating yung pansinin, class, na merong damages. So, anong rule kung kasalanan ng debtor? May nawala, kung ano yung huling nawala, yun ang value. Okay? Yun ang value na kanyang babayaran. Okay? O, tapos, at saka kung nawala, syempre, value, yun ang nawala, or kung yung mga services na imposible, babayaran niya yung amount. But, of course, kasama dito, may damages. Okay? If only one of the objects remains, the debtor must deliver the creditor the remaining object. Consequently, the obligation ceases to be alternative and it becomes simple obligation. Syempre, ganun yun. Pag natira na lang isa, simple obligation. Pag 2 or more of the objects remain, the debtor must deliver that which he shall choose from among the remainder. Consequently, obligation still subsists, retaining its alternative character. Kasi dalawa pa. Ibig sabihin, pwede pa rin mamili yung debtor. Pero once na nakapamili na yung debtor, it loses its character of being an alternative, thus making it a simple obligation. Okay? Pag nawala ang object, okay, lost due to fortuitous event, all of the objects are lost, obligation is extinguished. So, yan ang effect ng ating fortuitous event based on the alternative obligation. Okay? As I have discussed earlier, nagdoble yata yung slide ko, class. Okay? So now we move to facultative obligation. An obligation where only one prestation has been agreed upon but the obligor may render another in substitution. Ito lang naman yung isa lang ang napili ng ang napag-agrihan nilang dalawa, Pero yung obliger may render another in substitution. Okay, bigyan kita ng relo, pero pag nawala yung relo, di bigay ko na lang sa'yo cellphone. Ganon. Okay, hindi yung relo or cellphone or tablet. Pag hindi ko nabigay yung relo, bigay ko na lang sa'yo yung cellphone. O, pag nawala pa, di bigay ko sa'yo yung tablet. Okay? Ano yung effect of loss or deterioration of substitute in facultative obligation? Ano yung effect pag nawala or nasira ng substitute? Pag before the substitution, he lost or deterioration of the thing intended as a substitute through the negligence of the obliger does not render him liable. Okay? Pero after the substitution, sinabi niya na the obliger is liable for damages for the loss or deterioration of the substituted. Pero yung sa una, before, walang liability yon kasi pwede pa naman may kapalit pa. Pero pag nasabi niya na yung substitution, ito na ibibigay ko sa relo, may damages na yun. Parating yung isipin class yung damages. Merong damages pag merong pag nagkaroon ng loss or deterioration pag kasalanan ng debtor. Now, Section 4, the joint and solidary obligation. Okay? Pagdating sa joint and solidary obligation class, you have to understand first that in joint, pag sinabi mo kasing class na joint obligation yan, okay, ito yung tinatawag na which is defined as an obligation when there is concurrence or several creditors. Okay, several creditors. Tapos, by virtue of which each of the creditors has a right to demand and each of the debtors is bound to render compliance with its proportionate part of the prestation which constitutes the object of the obligation. Class, ang kagandahan sa joint, siyempre kung ang sinasabi lang naman dito, pwedeng maraming creditor, pwedeng maraming debtor. Okay? But it doesn't mean na isa lang ang creditor. Pwedeng creditor, isang creditor, maraming debtor. Pwede ring maraming creditor, isa lang na debtor. Okay? Ang pinag-uusapan naman dito is not the obligation itself, but the number of the debtors or creditors. Pag multiplicity or multiple creditors or debtors, it may be joint or solidary. Pag joint class, kung gaano karami yung creditor o gaano karami yung debtor, i-divide nyo. Then, pero, siya will be, yung isa doon will be will pay or will be obliged up to his proportionate share lang. Okay? Proportionate share lang. Okay? As compared to solidary, siyempre, pag gaya nga ng example ko sa inyo, gawin na lang nating ABC para mas malaman nyo yung difference ng joint and solidary. Kasi sa solidary class, an obligation or one of the debtor is bound to render and each of the creditor has a right to demand the entire compliance of the prestation. Okay, I will give you an example para mas madali sa inyo kung ano yung difference ng dalawa, joint and solidary obligation. Okay? Pag sinabi mo class na joint obligation, sample ABC, tapos DEEF. ABC ang creditor, si DEF ang debtor. O di na lang muna ang debtor. Ulitin ko ha. ABC, debtor. D, creditor. Si D, sa joint, si D ay pwedeng mangolekta kay ABC ng kanyang proportionate share. Kung 9,000 ang utang, 3,000 si ABC. Okay? Maniningil si D kay A ng 3,000, kay B ng 3,000, kay C ng 3,000. O balik rin natin, creditor naman ng marami. Kung ang utang ni D sa creditor ay 9,000, magbabayad si debtor kay A ng 3,000, magbabayad si D ng 3,000 kay B at 3,000 kay C. Yan ang joint solidary creditor or joint joint debtor, joint creditor. Kabaliktaran. Okay. Paano naman pag solidary class? Pag solidary, ABC ulit, ang debtor, D ang creditor. Si D pwedeng mangolekta kay A ng buong 9,000. Kung di makabayad si A, pwede siyang mangolekta kay B ng buong 9,000. Same with letter C. Okay? So, ganun lang yon class. Now, on the other hand, pagbaliktad naman, creditor naman si ABC, debtor naman si letter D. So, si D, pwede siya magbayad ng 9,000 kay A. Kung wala si A, pwede siya magbayad ng 9,000 kay B. Kung wala si B, pwede rin siya magbayad ng 9,000 kay C. Yun yung tinatawag nating solidary. But class, you have to remember the words of joint and solidary. Kailangan matandaan yan. Kasi pag ginamit yan, alam nyo na solidary, alam nyo na joint. Pero kung walang terms na ginagamit para malaman nyo kung ito ay solidary or joint, ano ang assumption? As I have said, it is joint. In the absence of any terms of solidarity, then the obligation is joint. Okay? Kaintindihan, importante yan klasa. Absence of any words of joint, then it is absence of any word of solidarity, then it's joint. Okay? So, tandaan nyo yun, klasa. Tandaan nyo, memorize the terms ng solidary at saka terms ng joint. Okay? Memorize nyo, class, please. Okay? So, ano ba yung kakasabi ko lang? Yung proportionate share, of course, it cannot be inferred lightly, the liability solidary, only when the obligation expressly so states or when the law so provides or when the nature of obligation so requires. Again, ulitin ko ha, a liability is solidary when the obligation expressed, kailangan sinabi. Yun yung mga words of joint and solidary or sinabi ng batas. Gaya nga binigay ko rin example about even sa labor, nakalagay doon, solidary obligation ng employer ang kanyang employee. Okay? Same as the guarantee sa mga utang. And so, yun yung mga ating joint and solidary obligation. Now, what are the characteristics of joint indivisible obligation? No creditor can act in representation of the other joint creditor or creditors. Yan yung joint indivisible. No joint creditor can compel to fulfill the obligation of the other joint debtor or debtors, as I have mentioned earlier. Now, what is the effect of breach of joint indivisible obligation? According to Article 1224, a joint indivisible obligation gives rise to indemnity for damages from the time any one of the debtors does not comply with his undertaking. The debtors who may have been ready to fulfill their promises shall not contribute to the indemnity beyond the corresponding portion of the price of the thing or of the value of the service in which the obligation consists. Okay? The law is self-explanatory. The debtor who may have been ready to fulfill their promises shall not contribute to the indemnity. Hindi siya magdadagdag ko, okay, ready magbayad, wala akong pakialam dun sa iba. Yung iba, magbayad sila ng kanilang, kung merong interest sila magbayad, pero ako hindi ako magbabayad because I am ready to pay my share of the obligation. Okay? Yun yung joint indivisible obligation. May kaibahan bang indivisible sa solidarity? Meron. Sa class, kasi pag sinabi nyo indivisible, pwedeng hati-hati ang obligation. Pinag-uusapan dito is the prestation. Unlike the solidarity doon sa kabila, ito naman ang pinag-uusapan dito is the juridical tie. It refers to the creditors and debtor. At saka sinasabi dito, class, ay isa-isahin ko na lang. Pag indivisibility, dito kahit na merong isang debtor, isang creditor, pwedeng indivisible ang kanilang prestation. Unlike sa solidarity, kailangan merong 2 or more debtors or creditors. Sa indivisibility, each debtor is not bound to fulfill the obligation more than his share. And each creditor cannot demand fulfillment obligation more than his share. Unlike sa solidarity, diba? Pwede mong i-demand dun sa buong debtor yung buong utang. At yung Vice versa, yung creditor, pwedeng tumanggap ng buong utang. As compared sa indivisibility, wala namang ganon. Okay? Ang kanya, yung share niya lang dun sa indivisible prestation. In case of breach of the obligation, the indivisible obligation is converted into indemnity for damages. Okay? Kung indivisible, di magbabayad ka ng damages. Plus, of course, indemnify mo. Thus, the indivisible character obligation is terminated. Bakit? Kasi mako-compute mo na yung damages into money. It becomes divisible already. Kaya na-terminate yung obligation. As compared to solidarity, in case of breach of the obligation, the solidarity character obligation remains. So, pag may breach, liable pa rin ang multiple debtors or creditors to accept. Okay? Ganun pa rin. In indivisibility, only the debtors guilty of the breach are liable for damages. Yung inano natin, pag guilty, yung hindi lang handa magbayad, siya ang liable for damages. Sa solidarity, lahat ng debtor are liable for damages. Kahit na isa lang ang may lagot. Kasi lahat sila bound Kasi solid nga sila Solid tayo. Ganun yun. Okay? In indivisibility, if one debtor is insolvent, the other are not liable for his share. Yan, class. Yan isa sa mga importanteng distinction ng indivisibility at solidarity. Pag yung isang debtor ay insolvent, yung other debtors, they are not liable to share. But in case of solidarity, if one of the debtors is insolvent, all the debtors who are solvent are proportionately liable for the share of the former. Maghahati-hati sila para dun sa liability ng isa. Pwede ba nilang habulin just in case? Pwede. Kasi sila lang ang magbabayad na. Sila magbabayad dun sa kanilang pinag-uutangan. Pero, syempre, of course, they should be rewarded also. They should be paid also. But, ano na yun? Proportionate share. Okay? What are the kinds of solidarity? As discussed earlier, legal solidarity based on law, conventional as agreed by parties, kailangan nandun yung terms of agreement, real solidarity imposed through the nature of obligation. Kung yung nature of the obligation is solidarity, then it is solidarity. Okay. As to parties bound, active solidarity, passive solidarity, mixed solidarity. Pag sinabi nyong active, yan yung creditor. Pag sinabi nyong passive, debtor. Passive, creditor solidarity. Pag active, yan yung creditor solidarity. Mixed, hati, or same. As to uniformity, uniform solidarity. And B, non-uniform or varied solidarity. Effects of beneficial acts and prejudicial acts of solidary creditor. Each one of the solidary creditor may do whatever may be useful or beneficial to the others, but not anything which may be prejudicial. So, kailangan pwede basta useful and beneficial, pwedeng gawin ng solidary creditor. Pero pag prejudicial, pag yung nakakasama sa kanyang kapwa, then it's not. Okay? Kailangan magandang may dudulot. What is the effect of demand against one of the solidarity debtors? It simply states that syempre, the demand of the against the solidarity shall not be an obstacle to those which are subsequently be directed against the others. So, pwede na naman mag-demand kahit kanino. Okay? Wala namang effect yon. Basta mag-demand ka kahit isa sa kanila. All you have to do is demand. So, effects of payment. Ito yung diniscuss ko na rin to sa inyong class in person. Payment, which means nabayaran. In any manner, the obligation is operative, which will entitle either of the solidarity to seek reimbursement the share which corresponds to each of the debtors. Payment by one of the solidarity debtors extinguishes. Siyempre, tinatanggal niya yung buong obligation. It is the whole obligation that's being extinguished. However, dito class, magbabayad yung other debtor doon sa nagbayad na debtor. Okay? A solidarity debtor who made the payment may claim from his debtors only the share which corresponds to each. Diba? Halimbawa, 9,000 as example earlier, nagbayad ako ng 9,000 kay A. Di dapat nagbayad ako ng 9,000 kay D. So, dapat si B magbabayad ng 3,000 sa akin. Si C magbabayad din ng 3,000 sa akin. Okay? So, ganun lang yun. Okay? Doon ako maghahabol. So ngayon, sila na ang debtor ko, ako na ang creditor nila. Okay? What is suretyship contract? By definition, refers to an agreement where under one person, yung isang tao, the surety engages to be answerable for the debt, default or miscarriage of another known as the principal. Ngayon, surety lang is para lang sabihin na sure na magbabayad siya. A and B. Si B ang surety. So si B ang naggagarantya or nagsisure na babayaran ni A ang utang niya kay X. So that is suretyship. Okay? Usually class, yung mga suretyship, meron ding bayad yan. Kasi sila yung maggagarantya. Kasi sila ang hinahabol just in case na hindi sila magbayad. Solidarity and suretyship, sabi nga na Supreme Court, in case the surety has specific meaning in our civil code. By guarantee, a person is called guarantor, binds himself to the creditor to fulfill the obligation of the principal debtor in case the latter should fail to do so. Just in case na hindi mabayaran, so the latter, yung latter ang magiging tagapagbayad. Okay? So that is suretyship. Effect ng payment ng solidarity debtor after it has been prescribed or become illegal. A solidarity debtor who made the payment may claim from his debtor only the share which corresponds to each with the interest of the payment. However, payment which entitle him to reimbursement from his co-debtors if such payment is made after prescribed become illegal. Okay? Pwede pa rin naman. Okay? Pwede pa rin naman siya maningil. Okay? Pero the thing is, it is already extinguishes the obligation. Okay? Now, ano yung rule in case the thing has been lost or if the prestation has become impossible without the fault of one of the solidarity debtor? Extinguish. Nawala. So, the obligation is extinguished. Rules in case the thing has been lost or if the prestation has become impossible through the fault of the solidarity debtors. All of the solidarity debtors shall be liable to the creditor for the price and the payment of the damages and interest. However, this is without prejudice to their action against the guilty or negligent debtor. Rule in case of the thing has been lost or if the performance has become impossible through fortuitous event but after one of the solid debtors has incurred legal delay. Rule in case of the things has been lost or if the performance has become impossible through fortuitous event but become one of the solidarity debtors has incurred legal delay. Okay? Ganun lang yun. So you just have to follow the rules on fortuitous event. Go back to chapter 2 to read the rules on really fortuitous event. Rule in case the thing has been lost or if the prestation has become impossible through the fault of the solidarity debtors. Number 1, defenses derived from the nature of the obligation. Depende kung ano ba yung nature ng obligation. Number 2, defenses which are personal to him or pertain to his own share. So this is called partial or total defense. Class, pag-aralan nyo na lang yung mga rules sa fortuitous event. That is, I think, chapter 2. Nasa chapter 2 yung class, ha? These are very, very important. Section 5, divisible and indivisible. So, pag sinabi mong divisible obligation, you speak of which are those that have subject, object, a prestation which is susceptible of partial performance without the essence of the obligation being changed. As compared to indivisible, on the other hand, are those which have as their object a prestation which is not susceptible of partial performance because otherwise, the essence will be changed. Siyempre, importante class yun kasi magbabago. Diba? Yung essence ng kanyang obligation kung ito ay indivisible or divisible. Okay? So, divisible, yun lang yun. Divisible, siyempre, pwede mo siyang hati-hatiin. But indivisible, in sense, pwede mo naman siyang hatiin, but masisira kasi yung essence, magbabago. Yung value kasi masisira. Pwedeng quantitative, Ang division, pwedeng qualitative, pwedeng ideal, or intellectual. Yung kanilang paghahati. Okay? Pag sinabi mong quantitative, syempre yung quantity. Pag sinabi yung quality, qualitative. Intellectual is when the thing can be only be separated into ideal or undivided parts. In case of a breach of joint indivisible obligation, it is converted into an indemnity for damages. So, pag nagkataon class, may indemnify na for damages just in case mayroong breach dun sa indivisible obligation. Okay? For those joint debtors who may have been ready to comply, again, hindi sila magko-contribute sa damages. Obligations deemed indivisible, obligation to give definite things, and those which are not susceptible to partial performance. Same naman. In this case, divisibility or indivisibility shall be determined by the character of the prestation. Ito yung mga obligations not to do. Okay. Section 6, obligations with the penal clause. In obligations with a penal clause, the penalty shall substitute the indemnity for damages and the payment of interest in case non-compliance. If there is no stipulation to the contrary, nevertheless, damages shall be paid if the obliger refuses to pay the penalty or is guilty of fraud in the fulfillment of the obligation. The penalty may be enforced only with its demandable accordance with the provisions of the code. Sinasabi lang dito, class, yung penalty kasi is a substitute. Dito yung substitute for indemnity of damages and payment of interest in case of non-compliance. Okay? Kung wala namang stipulation, it is the law that will operate. Nevertheless, damages shall be paid if the obliger refuses to pay the penalty or is guilty of fraud. What is an accessory obligation? Na-discuss na natin to. Now, an accessory obligation has been defined as that attached to a principal obligation in order to complete the same or take its place in the case of breach. Okay? Note, therefore, that an accessory obligation is dependent for its existence on the existence of a principal obligation. Yan ang accessory obligation. A principal obligation may exist without an accessory obligation, but an accessory cannot exist. Yan sinabi ko example, yung mortgage and the loan. Main obligation is indebtedness or yung loan. Ang accessory is the mortgage. When is penalty demandable? In case of non-performance or late performance of the main obligation. Requisites for the demandability of penal clause: that the total non-fulfillment of the obligation or defecting fulfillment is chargeable to the fault of the debtor. That the penalty may be enforced in accordance with the provision of law. Ano yung penalty in relation to the concept of mora? A penal clause is an accessory undertaking to assume great liability in case of breach. Double function ito, class. Siyempre, to provide liquidated damage. Siyempre, may damage ka na dahil meron delay. So, magbayad ka. Tsaka siyempre, para magkaroon ng force or threat, yung ating responsibility para umiwas sa breach or hindi mo gawin yung iyong obligation. Yun ang importante ng penal clause para to ensure performance. Yan ang isa sa mga purposes niya. And the second purpose is the penalty shall substitute. Gaya ng sabi ko nga, indemnity for damages. Okay? What else? Kinds of penalty. As to origin, it is legal when it's constituted by law. Pag sinabi mo legal, law yan. Pero pag conventional, agreement by party. Purpose, compensatory, para magbayad. Punitive, para punish ang obligor. As to effect, subsidiary, dinedemand mo kasi in case of breach. Pero joint, when the injured party may demand enforcement, both penalty and the principal obligation. So, yun yung penal natin in nature. Effects of nullity of the penal clause. The nullity of the penal clause does not carry with it that the principal obligation, okay, hindi yung principal. Kung yung penal clause ay null and void, hindi ibig sabihin yung principal obligation ay null and void. Okay? Pero effects of nullity of the principal obligation, syempre pag null ang principal obligation, consequently, the penal clause is also null and void. Okay? Thank you very much, class. We will continue our lecture and ayusin natin maigi as soon as we are back in class. Thank you very much.